Greetings and salutations. Welcome to Havoc and Chaos Live, a small glimpse into the batshittery we call news. And warning, I do swear, and I am very excitable. So if 4-letter words or longer offend you, you may want to go listen to something else. Today, I'm going to open with the words from the incomparable George Takei.
While this is a bit of a circus, so let us be clear, this woman is no hero to be celebrated. She broke her oath to uphold the Constitution and defied a court order so she could deny government services to couples who are legally entitled to be married. She is entitled to hold her religious beliefs, but not to impose those beliefs on others. If she had denied marriage certificates to an interracial couple, would people cheer her? Would presidential candidates flock to her side? In our society, we obey civil laws, not religious ones. To suggest otherwise is, simply put, entirely un-American.
My original plan, I wasn't going to touch the Kim Davis affair in any great detail. I mean, seriously, how much more can one small-time blogger add to the conversation? And, in all honesty, Mr. Sewell summed up the whole debacle in his statement alone. Simply put, Kim Davis broke the law, and the law won. There is no other way to look at it. You can argue semantics all you want, natural law versus the Constitution, state versus federal jurisdiction, discrimination versus religious accommodation, etc. But, and let me just say as a brief side note as to how ridiculous this is becoming, one self-appointed political know-it-all has tried to compare the whole religious liberty facade, specifically Davis, to imprisoned missionary Saeed Abedini. Where he goes wrong in his analogy, Iran is an Islamic theocracy, where there is no separation of church and state. Another has gone so far as to say that Davis is the Rosa Parks of our era. No. The one small point I will make concerning an issue of semantics is a statement Davis made herself.
To issue a marriage license which conflicts with God's definition of marriage with my name affixed to the certificate would violate my conscience.
Now, folks, this is just lying for Jesus, because it ain't so. Davis regularly issues marriage licenses in conflict with her so-called definition of biblical marriage. She is not adverse to allowing divorced couples to marry at all. As much as I hate to admit it, it is one point the Westboro Baptist Church has right, although the primary focus of their ire is Davis herself. Typical fundamentalists view the once married, always married point of view. By Kim's own logic, every license she signs for a divorced local couple is a violation of God's definition of marriage. That aside, a recent discussion surrounding the whole faux Christian persecution complex has highlighted one point that has not really been discussed: special pleading, or religious exceptionalism. And if you have followed my blog, it is a point that I have highlighted numerous times before, starting with none other than Hobby Lobby and its aftermath. Now, before we begin, I will not be arguing whether Davis is a, quote, true Christian, or whether her religious convictions are hypocritical in light of her divorces and marriage, nor will I touch on whether what she spouts is actually what she believes. In other words, is she seeing dollar signs, or is she getting piss-poor legal advice? What is at issue is plain and simple. The First Amendment does not give Kim Davis the power to decide whether same-sex marriages are lawful in the state of Kentucky. That question was settled this summer by the Supreme Court, which ruled 5-4 that the U.S. Constitution guarantees the freedom to marry in all 50 states. Davis's private, personal beliefs are covered by the First Amendment, but when she steps into her official role, she is no longer a private citizen. She is now an agent of the government, and the same First Amendment that protects her private freedom of religion bars the government from having any official religious beliefs. So let's go back and take a look. If you remember, prior to oral arguments being heard in Hobby Lobby, I highlighted an interview with Barry Lynn of the Americans United for Separation of Church and State. Mr. Lynn, speaking in general terms of the scope of Hobby Lobby, said this:
But what the religious right really wants out of this is the right to opt out of any federal or state laws that they don't like because it allegedly or actually violates one of their religious principles.
Now, granted, Lynn was speaking in regards to for-profit businesses such as Hobby Lobby, but 6 months later, after the final ruling by SCOTUS, the Reich was fucking pissing their pants with glee. According to Right Wing Watch, Matt Barber is hopeful that anti-gay Christians will now have a solid defense when they refuse to be an indentured servant by providing services to a counterfeit gay marriage, because this ruling was a strong rebuke of all those sexual orientation laws around the country in cities and municipalities and states that say somehow gays win, Christians lose, sexual orientation trumps all. It was a sentiment echoed by many within the Reich, as their devilish minds worked an unexpected wind to their advantage in advancing their agenda. Now keep in mind, I personally believe the Reich never expected to win, and that the Hobby Lobby case itself was a test case, and nothing to do with contraceptives at all. That brings me to something I wrote a month later, and something Barry Lynn had already suspected. When one looks at the decision rendered by SCOTUS, it has to be through the lens of the Reich's overall agenda, starting with a reformed interpretation of the Free Exercise Clause, or an outright repeal of the First Amendment, continuing with the abolition of the Civil Rights Act of 1964, ending with the implementation of dominionist theology in order to govern by theocratic control. And that is the crux of the whole Hobby Lobby case. With the ruling in Hobby Lobby, the Reich will now be able to exempt themselves from any laws they don't like, that they find religiously objectionable. Sound familiar? Make no mistake, the Kim Davis affair is just another cog in the wheel of the Reich's agenda. Just like former Atlanta Fire Chief Calvin Cochran, florist Baronel Stutzman, bakers Aaron and Melissa Klein, Mennonite couple Dick and Betty Ogard, and former Air Force Sergeant Philip Monk, and trust me, there are many, many more. That was just the highlights, to set the tone, so to speak. There's too much minutiae regarding the politics, and I'd probably bore you all to death. So, onto this notion of special pleading or religious Christian, accommodation for religious belief, and why it would be a bad judicial precedent. This is my current working definition, how I look at it. Invoking your personal interpretation of the religious dogma that your particular religious group teaches onto other individuals in order to outright deny a service or product, not taking into consideration possible accommodations that could be made. Then, when the denial of service discrimination is called into question based on applicable law, said religious beliefs are invoked as a defense under a twisted interpretation of the First Amendment. Now, a few things to keep in mind. 1. The courts generally do not rule on whether a religious belief is genuine. 2. The Kim Davis affair, in my opinion, is pretty straightforward, as Davis is an agent of the government. And by accommodation, I mean simple. You apply for a job, you get the job. Oh, worship services are on Friday. We can accommodate you. Can you work Saturdays instead? So the question in the Davis affair becomes this. Is it acceptable for religious beliefs to undermine lawful civil rights protections? Now, remember, keep in mind the overall agenda. The simple answer is no, as Takai noted. According to the U.S. Constitution, religious freedom does not equate to religious entitlement. While the First Amendment protects the free exercise of religion, the Establishment Clause prohibits the government from establishing an official religion and forbids religious favoritism, which is why Davis's actions are particularly egregious. As Judge Bunning himself stated, the idea of natural law superseding this court's authority would be a dangerous precedent indeed. There is no such thing as natural law in a secular society, at least not in the manner the Reich is insisting. That's a whole nother ball of wax to contend with. To Davis et al., it means one thing, God's law, or more apt, my interpretation of God's law, or quite succinctly, Sharia. As you can see, this mess is more than just about Kim Davis. There is so much other stuff mixed into the bag of goods being sold to the public by the Reich, it would take the patience of Job to sort it all out. Besides the above natural law discussion I mentioned, there is a piss-poor analogy to Dred Scott, and for shits and giggles we have Rena Lindenbaldsen, who works for Liberty Counsel, who has taken to arguing that Christians have the right to overthrow the democratically elected government and simply impose their will by fiat. What she's suggesting is a sovereign citizen motif. Davis is a pawn of her own legal team, and she's blinded by the idea that religious conservatives are entitled to ignore or even overthrow democracy and seize power just because they feel like it. And now, back to the show.